Good morning. Is the jail ready to go?
Yes.
Okay, thank you. And Mr. Heydrich, you're ready as well?
Thank you. I
We are
couldn't hear
ready.
the state answered.
Yes, Your Honor, I did. My apologies.
Thank you. Good morning. We're here today for the in-custody arraignment calendar. Today is December 25th. Are there any special requests regarding today's order proceedings or requests for continuances before we begin?
Yes, Your Honor. Good morning. Hunter Heydrich for the state. I do believe that we'll have a victim present on the Pietro Short case.
And we do have somebody in the Zoom waiting area for that case.
Name will be Crystal McIntyre.
We do have a
Thank you.
Crystal McIntyre waiting.
Outside of that, the state has no special request, Your Honor.
Defense has no special request either.
Thank you. We'll go ahead and begin with Keyshawn Sheridan, followed by Pietro Short.
Sheridan's up.
So you'll have your court date to talk about that. Yes. Okay.
Sure.
Good morning. We're here today for an arraignment. Sir, do you have a copy of your criminal complaint?
Now I have, yes. I just got it.
Thank you. Is your legal name correctly spelled on line 7 of that document?
Yes.
Thank you. Have you had a chance to read the charges, and do you understand, not do you agree, but do you understand what you're charged with?
Yes.
Thank you. We will go ahead and waive a formal reading. And defense counsel, what hearing are we setting next? Or I believe, yes, what hearing are we setting next?
We are setting a speedy preliminary hearing, Your Honor.
Thank you. We will note that the defendant is invoking his right to a speedy preliminary hearing. And Madam Clerk, what date is available in approximately 15 days?
Judge, so on his other matter, he is currently set for a speedy prelim on the 31st of December. I don't know if that's too soon for parties or if that would work.
No, I took bills for those cases on the 18th. They all was misdemeanors. And I took bills for them, so I took misdemeanors.
So, sir, I'm going to have you hold on one moment. Of parties, does that date work for this case?
Your Honor, I believe that's too short of a timeline. That basically gives us 2 days to ensure our witnesses are present. So I would ask for something closer to the 15-day mark.
All right, so we can do January 8th at 1:30.
Thank you. Does that date work for the parties?
It does, Your Honor. Thank you.
Yes, Your Honor. And
If not sooner, because I took bills for the other cases.
Thank you, sir. I'm going to have you hold on one moment. Sir, your attorneys, sir.
I took misdemeanors. They can't violate me without any felony.
Sir, I'm going to have you be removed from the courtroom if you do not hold on. Your attorney is trying to speak.
Yes.
Ms. Cook.
we're not talking about that right now.
Well,
Your Honor,
I would
he
like
does have a citation also pending that he was
We are
supposed.
not going to address that here today.
No, I just wanted to make sure because there was a warrant pending when he was still in custody saying that he failed to appear at that hearing. So I just wanted it to be on the court's record that he is in custody. And so if there is a future date set on that citation that he's not failed to appear.
I never knew nothing about the citation.
Thank you. We'll go ahead and set a motion to.
Thank
you, sir. With the Washington County Jail.
The only thing
Thank you.
I'm fighting is supervision. They can't violate me without a felony. I don't have no
Thank you. And what is the motion to confirm date, Madam Clerk?
Sorry, Judge. It would be for December 30th.
Thank you. So that'll be the motion to confirm at 1:30 p.m. Thank you.
Thank you, Your Honor.
Thank you. Next, we have Pietro Short, followed by David Galindo Cloud. Madam Clerk, can you pull in that individual?
Yes, it's loading. She's coming in.
Thank you. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent the defendant. I am in receipt of a Nevada pretrial risk assessment, which indicates the defendant scored as a 14 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor, I am. Your Honor, in this case, the state is seeking bail in the amount of $100,000 bondable. As noted, Mr. Short does score a 14 on the risk assessment. This included not only the crime of attempted violence in the home invasion, but the eluding, which resulted in Mr. Short fleeing from law enforcement and eventually jumping off of the lakeside, the Lake Street Bridge, and into the Truckee River in an attempt to avoid law enforcement. He was also found with a significant amount of methamphetamine on his person. He also has a pretty significant criminal history. It looks like he has already been arrested on other drug charges this year. He had failure to appear in that case. He was ended up being convicted of 2 drug paraphernalias this year, one out of this court, one out of the Sparks Municipal Court. He also had a misdemeanor resisting conviction this year. He also pled guilty to 2 DUIs out of this court this year, as well as another obstructing. Looking at only his prior felony convictions, he had a 2022 felony conspiracy to commit robbery out of Las Vegas, a 2020 felony attempted grand larceny of an automobile and attempted possession of a stolen motor vehicle. In 2018, he had 2 separate felony convictions for grand larceny of an automobile and a 2017 felony conviction for attempted possession of a stolen motor vehicle. I would also note that he had a misdemeanor menacing constituting domestic violence conviction out of Oregon in 2015 and a misdemeanor harassment conviction out of 2019. So given that history, Your Honor, we do believe bail to be the least restrictive means. We would ask for house arrest with GPS monitoring, DAS supervision with testing for drugs and alcohol, a no firearms or weapons clause. It's my understanding that Ms. McIntyre is not seeking a no contact order, but given the facts of this case, Your Honor, and Mr. Short's criminal history, I do believe that a no contact order is appropriate in this case.
Thank you, defense.
Thank you, Your Honor. In regards to Mr. Short's situation, he is not able to afford the amount of bail that the state is requesting at this time. And speaking with him, he would only be able to afford about $1,000. We believe that there are other conditions that the court could impose in order to ensure his future appearance at court and protect the community. He is interested in a program for co-occurring disorders. He did recently participate in adult drug court. He was employed at ZZZ Auto Repair for about 8 months. We also were able to confirm that he does have a phone number and that he does have a residence at the El Cortez, which I think was also mentioned in the probable cause sheet as well. That would lower his risk assessment score. So we would ask the court to release Mr. Short with conditions related to checking in and testing. As I mentioned, he is also interested in participating in a treatment program. So if the court is inclined to set a higher monetary bail, we would also ask that he be given the opportunity to apply for and be accepted into a program. And once a bed date is secured for him, that he be able to be directly transported by the Inmate Assistance Program or Detention Services Unit to that bed.
Thank you. Ms. McIntyre, the law affords you an opportunity to be heard as the named victim in this case. If you wish to say anything, I'm going to first have you be sworn in. So just say yes if you do wish to say something.
Yes.
Thank you. Please raise your right hand. Do you swear or affirm that the testimony that you shall give today shall be subject to the penalty of perjury according to the laws of the state of Nevada and shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please state your name and spell your last name for the record. And you can lower your hand. Thank you.
Okay. Crystal McIntyre, McEntire.
Thank you. And I don't know what the victim advocate or investigator provided you with information, but the purpose for today's hearing is just regarding release. So whether or not the defendant can be released on his own recognizance, or if there's any conditions that should be imposed in order to ensure your safety, the safety of the community, and his appearance. You've heard that the state's requesting a no contact order. And if you have any concerns for your safety, now's your opportunity. So I'll let you go ahead and speak if there's anything that you wish to say.
I work in treatment and I don't have any concerns for my safety. Like I'm totally supportive of him. I think that he was in a induced like psychosis and thought that he needed to protect me and somebody was in my home. And I feel like that's why he broke into my home, because when he came in and saw nobody was like harming me, he fled. So I don't believe that he was trying to harm me. I think that he really does need a program, and I'm really here to be supportive for him because he doesn't have family and he doesn't have anybody. So
Thank you. I appreciate that. State, do you have any questions?
No, Your Honor.
Thank you. Defense, do you have any questions?
No, Your Honor.
Thank you. Thank you for being present here today, ma'am. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community and the appearance of the defendant. I will note the failure to appear, the higher Nevada pretrial risk assessment. I will note the reduction based off of the information verified by the public defender's office. However, given the likelihood of conviction as well as the issues as discussed in the criminal history, I do find that bail is appropriate on this case, and it will be $30,000 that will be bondable with no 10% cash option based off of the nature of the charges. As always, if those charges change, the parties may request for a bail reduction on that basis. Additionally, I am requiring that the defendant be supervised by pretrial services. So, sir, you must check in with pretrial services within 1 business day of release. I am imposing the condition that you cannot use any controlled substances or alcohol, including marijuana, unless you have a valid prescription, and be subjected to random drug and alcohol testing. Additionally, I do find it appropriate, given the allegation of a crime of violence, that you cannot possess any firearms or weapons, and so that will be imposed as well. The court did consider a release through direct transport to an inpatient or a residential treatment facility. However, without additional information, the court does not have sufficient information to find that that is the least restrictive means. So defense counsel, if you have, if he's accepted into an appropriate program, feel free to provide that information to the court and we can address that at that point. But at this point, the court does not find that that is appropriate as the least restrictive means. And so that will be the order of the court, and we will go ahead and set a 72-hour hearing. And Madam Clerk, when will that 72-hour hearing be?
It'll be for January 2nd at 9:30 a.m.
Thank you, and I'm not imposing a no contact order at this time.
I can call her if I want.
Thank you, Your Honor.
Thank you.
thank you.
Thank you again for being here, and that concludes this hearing.
Thank you, ma'am.
Next, we have David Galindo Cloud, followed by Ricky Hubbard.
There's no like 10%.
Do a bail bond.
Who was up?
Your Honor, he is not present. We were to request his appearance be waived.
And this is for Mr. Galindo Cloud.
Yes, Your Honor.
Thank you. We'll go ahead and waive his appearance for today's proceeding. We're here today just for the bail hearing that was continued at defense's request. Defense counsel, are we able to proceed here today?
We are, Your Honor. Thank you.
Thank you. State, please proceed.
Thank you, Your Honor. As you may recall from yesterday, the state is going to seek a bail in the amount of $100,000 bondable, pretrial supervision with testing for drugs and alcohol, house arrest with GPS monitoring, and a no firearms clause given the facts of this case, and that Mr. Galindo Cloud is a previously convicted felon. Your Honor, the facts of this case are concerning Mr. Galindo Cloud fleeing from a traffic stop, which the truck is later found with the backpack containing the large amount of controlled substances. Most concerning to the state is the fact that Mr. Galindo Cloud did have so many cases pending before this court and before the Sparks Justice Court, all felonies, 4 separate felony cases pending when he now picked up these new charges. Previously, Mr. Galindo Cloud was convicted of felony trafficking in 2011. He also had a felony conviction for possession of a controlled substance in 1999. It does look like he has other felony arrests. However, one was a 2007 robbery out of this court, which was dismissed due to lack of witnesses, and a gross misdemeanor possession of a dangerous weapon in 2008. Given that history, Your Honor, we do believe he presents an ongoing risk of further criminal activity, risk of non-appearance, and a risk to the community. So we do believe bail to be the least restrictive.
Thank you. Just with respect to counsel, you indicated that based off the allegations in this case, that it is appropriate to not impose or to impose the condition that he not possess any firearms or weapons.
Yes, Your Honor, the flight from law enforcement. I think just the no firearms would be appropriate instead of no weapons, as it does not look like a weapon was used here. However, given the fact that he is a felon, I would ask that they no firearms clause remain.
Thank you. Defense counsel?
Thank you, Your Honor. In regards to Mr. Galindo Cloud, he is already in custody and has been in custody for 2 weeks now. He has significant bail out of the Sparks Justice Court, totaling $30,000 cash only. And then he has his bail and his other case out of Reno Justice Court at $15,000 bondable. With those 2 cases already pending, he is not able to afford the amount of bail that the state is requesting at this time. He does have a place to live, a phone, as well as and he is also self-employed. We would ask, given the significant amount of bail that he is already facing out of his other cases, that this court not impose the amount requested by the state, as he is clearly not able to afford that bail, given that he's been in custody for 2 weeks.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in order to ensure the safety of the community. I will note the history involving similar offenses, the history involving that he's currently pending several cases that are felony cases, and with that in mind, as well as the likelihood of conviction and the threat to the community, bail will be set in the amount of $40,000 that will be bondable with no 10% cash option based off of the nature of the charges. The court will impose that the defendant be required to be supervised by pretrial services, and so if he's able to post that bail amount, he will be required to be to check in within 1 business day of release. I am imposing the condition that he be subjected to random drug and alcohol testing. I do find that there's a sufficient nexus to require that. State he's already required based off his felony conviction to not possess any firearms. I'm not going to impose that as a specific condition of this case. He's required to obey all laws, which includes that. I'm not going to include the house arrest or GPS monitor. I don't find that there's a sufficient basis to require that. That will be the order of the court, and we'll go ahead and set a 72-hour hearing. And Madam Clerk, will that also be for January 2nd at 9:30 a.m.?
No, Judge, he will be for December 31st at 9:30 a.m.
Thank you. That'll be the order of the court. Thank you. Thank you. Next, we have Ricky Hubbard, followed by Deanne Snow. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 12 or a high risk. And my apologies. The information I have is, Madam Clerk, can we confirm? I had information that a public defender was needed, and I just see that one has been appointed. Just want to confirm that one has been appointed.
Let me double check, Judge, but I also believe that APD was appointed.
Thank you. State, are we ready to proceed with the bail hearing?
Yes, Your Honor. In this case, the state is going to seek bail in the amount of $5,000 bondable with no additional conditions. Mr. Hubbard does score 12 on the risk assessment, noting 2 of those points being for prior failure to appear, 1 point for a prior violent crime conviction. He has racked up a number of other things, including a gross misdemeanor conviction for battery on a protected person this year. Looks like he's serving a jail sentence on that case. PSI in that case notes 4 prior felony convictions, including a 2015 possession of a controlled substance, 2015 aggravated domestic violence, a 2015 promoting prison contraband, and a 2008 possession of controlled substance with intent to deliver. It also notes 17 prior misdemeanor convictions. Given that, and he also has history out of 3 separate states, including Idaho, Arizona, and now Nevada. Given that history, Your Honor, we do believe some monetary bail is appropriate in this case.
Thank you, defense.
Court's indulgence, Your Honor.
Just a few days ago.
Thank you. And while you're doing that, just for the record, in case we did not appoint a public defender at this point, based on the facts and circumstances, the court does find that there's a basis in the interest of justice that a public defender should be appointed.
Your Honor, so in regards to Mr. Hubbard's case, as the state indicated, he is already under sentence for a prior case. He was sentenced not too long ago to serve 6 months in the Washoe County Jail. I would ask, given the amount of time that he will still have remaining on this case, on that sentence, excuse me, that the court release him on his own recognizance in relationship to this damage to jail property allegation, just given Mr. Hubbard's inability to afford any monetary bail, and the fact that hopefully this matter can be resolved while he's under sentence in his other case.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note, based on the facts and circumstances, that he's currently serving a sentence while in custody and while is alleged to have committed this offense, the likelihood of conviction, as well as with that Nevada pretrial risk assessment, bill will be set in the amount of $3,000 that will be bondable with a 10% cash option, and no other conditions will be required. Madam Clerk, when will the 72-hour hearing be?
That'll be for January 2nd at 9:30 a.m.
Thank you. We'll see you back here in court on that date and time. Next, we have Dan Snow, followed by Justin Cloley. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 4 or a low risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. In this case, the state is not going to object to Mr. Snow's release. We are requesting that he be supervised by either Department of Alternative Sentencing or pretrial supervision with testing for alcohol, and that he have a no weapons clause, given that this is crime of violence. Mr. Snow scores a 4 on the risk assessment and has no documented criminal history.
Thank you. Defense?
Yes.
Your Honor, in regards to Mr. Snow's case, we are asking that he simply be released on his own recognizance without any conditions. As the state indicated, he has no prior history. This represents his first arrest. We were also able to verify his employment, residence, and phone, which would bring his risk assessment score to a 0. And for those reasons, and given his lack of history, I don't believe that conditions other than make all future court appearances and obey all laws are necessary in his case.
Thank you. The court does find that the state has not met its burden by clear and convincing evidence. And so, sir, you will be released on your own recognizance here today, as that our least restricted means that can be imposed in order to ensure the safety of the community. You will be required to make all court appearances as well as obey all laws. And Madam Clerk, when will the arraignment be?
The arraignment will be for January 8th at 9 a.m.
Thank you. We'll see you back here. You need to check in with Reno Justice Court at 9 a.m. So make sure that you appear in Reno Justice Court on that date and time. Thank you.
And Judge, just to clarify, are we appointing PD? He had indicated he was going to retain counsel.
Thank you, sir.
Yes, ma'am.
Thank you. Do you wish to see if you qualify for the public defender's office, or do you wish to see if you're more than welcome to always retain a counsel, but I can determine if you qualify today for a public defender.
I was planning on retaining my own. I don't know the requirements. I suspect that financially I wouldn't qualify.
Thank you. We'll just have this, Madam Clerk, if you could note that this will be readdressed as arraignment.
Thank you.
Thank you.
Thank you. Justin Cloley, followed by Shannon Giambetti.
Morning, ma'am.
Good morning. We're here today for an arraignment as well as a bail hearing. Do you have a copy of your criminal complaint?
I do, ma'am.
Thank you. Is your name correctly spelled on line 7 of the document?
I do. Yes, it is.
Have you had a chance to read the charge or the charges and do you understand what you're charged with?
Yes, ma'am.
Thank you. We'll go ahead and waive a formal reading and we'll go ahead and turn to the bail hearing. Just for the record, the court is in receipt of the Nevada pretrial risk assessment and which indicates that the defendant scored as a 13 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Given that this was filed as misdemeanors, I'm not going to object to Mr. Clowley's release. However, given the facts, I would ask that he be supervised by pretrial supervision and tested for drugs and alcohol.
Thank you. Just for the record, the information that this court has is this is a no jail complaint. Is that correct?
Your Honor, that is correct. I did have the opportunity to review that with him and his potential option of entering a plea today. Given that information, he is prepared to move forward with pleading.
That's fine with the state, Your Honor.
Thank you. So, sir, this is what's called a no jail complaint, which means that the state of Nevada is not seeking any additional jail time for you on this case. Were you present at the Washoe County Jail when they played the video that discussed your constitutional rights?
I've seen the video before, yes, ma'am.
Thank you. And do you understand that you have the right to enter a plea of not guilty, no contest, or guilty here today?
Yes, ma'am.
And which plea do you wish to enter?
Guilty.
Thank you. I'm going to go through a series of questions with you. Do you understand that you do not have to enter a plea of guilty here today, and that by entering a plea of guilty, you're giving up all of those constitutional rights that were discussed, to include the right to have a trial where the state would be required to meet their burden of proving each element of this offense beyond a reasonable doubt?
Yes, ma'am.
Do you understand that the maximum sentence that I can impose is up to 6 months in Washoe County Jail, a fine of up to $1,000, and replace you on probation for up to 2 years?
Yes, ma'am, I do.
Have you had enough time to consider the potential collateral consequences that you may be facing as a result of the conviction in this case? For example, how this may impact immigration, housing, educational opportunities, your license, potential debt, parole, and probation case, things of that nature?
Yes, ma'am, I do.
Have you had enough time to speak with your attorney about the appellate rights that you're giving up by entering a plea of guilty here today?
Yes, ma'am, she did a nice job.
Thank you. Are you currently under the influence of any controlled substances or alcohol or medication that impacts your ability to understand what is going on here today?
No, I'm a clean. I take a thyroid med and a lot of Mucinex right now. So
Thank you. Just to be clear that does not impact your ability to understand what we are doing?
No, ma'am.
Thank you. Are you a member of the U.S. military?
No, ma'am.
Knowing that you're giving up those important constitutional rights, what is your plea to the only count in the criminal complaint of use or possession of drug paraphernalia?
Guilty, ma'am.
Thank you. I accept your plea of guilt. Finally entered it knowingly, voluntarily, under your own free will, and will proceed with sentencing. State, is there anything that you wish to add?
No, Your Honor.
Thank you. Defense, is there anything that you wish to add?
No, Your Honor.
Do you have credit for time served?
Your Honor, he's been in custody since the 23rd. So 3 days.
Thank you. Thank you, sir. The law affords you an opportunity to be heard. Is there anything that you wish to say before I decide what your sentence is in this case?
No, ma'am, I don't have anything to say.
Thank you. I will sentence you to 3 days in the Washoe County Jail. You will receive credit for 3 days. I do find that that is fair and appropriate given the facts and circumstances in this case. Thank you and good luck.
I mean, Merry Christmas, by the way.
Thank you as well.
Thank you. Merry Christmas. Merry Christmas.
Shannon Giabetti, followed by Richard Yeager.
Your Honor, Ms. Giambetti is not present. We did have the opportunity to speak with her, so we can move forward with her bail hearing.
Thank you. Are you also able to proceed with the arraignments?
We were not able to review with her the criminal complaint as that's typically handed to them when they come into the courtroom.
Thank you. There are 2 criminal complaints. Just want to make sure that's clear.
Correct, Your Honor.
But you wish to proceed here today with the bail hearing, or do you wish to continue all matters for tomorrow?
Your Honor, if we can continue all the matters for tomorrow, I think that would probably make most sense so that she can be arraigned and all of that together.
Thank you, State. Any objection?
No, Your Honor.
Thank you. I will grant a 1-day continuance. I do find that there's good cause, and so we'll go ahead and continue the arraignment and the bail hearings in both matters until tomorrow at 9:30 a.m. Thank you. Richard Yeager, followed by Troy Staton.
Yes, Your Honor.
Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 10 or a higher risk utilizing that tool. State, are we ready to proceed with the bail hearing?
Yes, Your Honor. In this case, the state is seeking bail in the amount of $10,000 bondable. DAS or pretrial supervision with testing for drugs and alcohol, comply with CPS or HSA regarding the minor child as identified in the probable cause sheet. And Mr. Yeager scores a 10 on the risk assessment, noting a pending case out of the municipal court and 2 points for prior substance abuse related arrests. In the past few years, Mr. Yeager has had multiple contempt arrests, one in last year, one in 2023, and one in 2018, all out of separate counties, but within Nevada. In 2017, he had a felony arrest for possession of a controlled substance out of California, where he received deferred judgment. He had a misdemeanor DUI conviction in 2006, a misdemeanor petty theft with priors in 2003, a 2002 felony conviction for possession or manufacturing methamphetamine out of California, and a separate case for felony receiving known stolen property out of California. He had a 2001 misdemeanor conviction for inflicting corporal injury to a spouse or cohabitant, and another possession of a controlled substance case, which was deferred in 1999. Given that continued history of drug use, Your Honor, I would call appalling facts of this case, Your Honor, the fact that I assume you've read the probable cause sheet, but the actions that Mr. Yeager took against the minor victim in this case are incredibly alarming to the state, as he was supposed to be her caregiver. So we do believe that he does present an ongoing risk of further criminal activity, risk of non-appearance given the nature of the charges and the facts of the case, and a risk to this victim if he does have contact with this victim again. So with that, Your Honor, we do believe the bail in those conditions to be appropriate.
Thank you. So are you requesting a no contact order?
So, Your Honor, I was requesting to comply with CPS and HSA, as I'm not sure about how they handle it. I actually was speaking to an HSA person yesterday about whether or not the no contact orders through them would be appropriate for the court. But I do believe a no contact order with the victim to be appropriate. I just assumed that that would come through HSA or CPS.
Thank you. So do you have information as to violence against the named victim?
Yes, Your Honor, the drawing on her face when she slept, the allegations of sexual abuse against the victim, as demonstrated in the probable cause sheet, based on Mr. Yeager's statements to his girlfriend.
That was, yeah.
So, Your Honor, I would say yes.
Thank you. Defense counsel?
Thank you, Your Honor. So first of all, the allegations of sexual abuse was a different perpetrator that had occurred, and Mr. Yeager did, from my reading of the probable cause sheet, facilitate a forensic interview of the child. So I believe that he did follow through as far as what is required, of a guardian to ensure that those allegations are brought to the appropriate person's attention. In regards to this case, he has lived in the area for a significant amount of time. We do know that he does have a residence based off of the probable cause sheet, and I found out this morning as well that he has paid up 2 additional weeks at that room. He also indicated to me interest in going into the Battleborn program.
Yes.
He thinks that is what he really needs right now, and really wants to go there to seek assistance for his addiction issues. He has not been currently working. He has been receiving financial assistance from his ex-wife as well. He is, as has already been mentioned, Child Protective Services through the Washoe County Human Services Agency is already involved in this case with the child. And so he will have, he will have additional support and supervision through that agency in terms of a case plan that would be developed by the court process there. in terms of attempting to reunify the minor child with him, if it can be done in a safe and appropriate manner that would address all of the concerns that have been outlined in the probable cause related to this arrest. And then finally, Your Honor, the pending case in Reno Municipal Court is the citation for failure to supervise that is noted early on in the probable cause sheet. He has yet to even be arraigned on that citation. I believe that date is not until next year to start dealing with that citation. So given all of the additional support and circumstances, given Human Services Agency's involvement in this case and their ability to supervise on a regular basis, do supervised visits when they deem it's appropriate, have him participating in his case plan, substance treatment, testing, and all of those things. We would ask that Mr. Yeager be released on his own recognizance, that any contact that he does have with the minor child is contact that is approved through the case plan of Human Services Agency, since she is currently in their custody, that he be supervised as well, pre-trial and tested. Like I mentioned, he is interested in the Battle-Born program. So he will be also seeking that resource and getting in there as well.
Yes.
Thank you. Based on the facts as presented, the Nevada Pretrial Risk Assessment and factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note the higher Nevada Pretrial Risk Assessment. I will note the allegations as contained. I'll just note for the record that the court does not read, and I just reviewed the PC sheet again for the third time this morning regarding this case. I don't read it the same way that as indicated by the state, and just note that there's not sufficient evidence to find with respect to the prior allegations that this court can use that. Just want to make sure that is clear for the record. I do still find that based off of the likelihood of conviction, as well as the harm to the named victim in this case, that bail is necessary in order to ensure the safety of the named victim and the community. Bail will be set in the amount of $5,000 that will be bondable, with no 10% cash option based off of the nature of the charges. I am requiring that the defendant be required to be supervised by pretrial services. So, sir, you must check in with pretrial services within 1 business day of release. You will be required to not use any controlled substances or alcohol, including marijuana or medication, unless you have a valid prescription. I do find that that is necessary in order to ensure the safety of the community, as well as if there's a sufficient nexus based off of the information provided. So you will be subjected to random drug and alcohol testing. I will grant an own recognizance release through direct transport. So this order will read bail or an OR release through direct transport to an appropriate treatment facility. Just for the record, additionally, I am imposing the condition that you are to have no contact with the minor child with initials RJ unless authorized by HSA. So I do find that that is appropriate. Additionally, you are required to comply with all HSA requirements. That will also be the order of the court. I do find that that is necessary in order to ensure the safety of the community. That will be the order of the court, and we will go ahead and set a 72-hour hearing, and that will be set for January 2nd at 9:30 a.m. Thank you. Thank you. Next, we have, just one moment.
That would be awesome.
So just when you get back to you, I'm going to ask them for the applications for the Battle-Born.
Thank you. Next, we have Troy Stratton, followed by Fernando Valle.
So,
Go back.
Sir.
Go ahead.
Let's go.
No, not today.
Good morning. We're here today for first appearance bail hearing. Probable cause has been found, and the public defender's office has been appointed to represent you. I am in receipt of the Nevada Pretrial Risk Assessment, which indicates that you scored as a 12 or a higher risk utilizing that tool. State, are we ready to proceed with the bail hearing?
Yes, Your Honor, we're not going to object to Mr. Stratton's release in this case. This is a very minimal amount of methamphetamine found on his person. It will likely be filed as a no jail complaint. Given that, Your Honor, I would just ask that his condition be make his next court appointment.
Thank you. Any objections to an unrecognizance release, defense?
No, Your Honor.
Thank you. So, sir, you will be granted an unrecognizance release here today. You will be required to attend your next hearing and obey all laws. And Madam Clerk, when will that arraignment be?
Yes,
That'll
ma'am.
be for January 8th at 9 a.m.
Thank you. We'll see you back here in court on that date and time.
Thank you so much. Merry Christmas.
Thank you as well. Fernando Valle, followed by Terrence Gray.
Your Honor, Mr. Valle is not present. We would request to waive his appearance this morning.
Thank you. We'll go ahead and waive his appearance for today's proceeding. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent him. I am in receipt of the Nevada pretrial risk assessment, which indicates that he scored as a 12 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. In this case, the state is seeking bail in the amount of $10,000 bondable, pretrial supervision, and no contact with Walmarts in the Washoe County area. Mr. Valle scores a 12 on the risk assessment as noted. He also has a pending case before this court, I believe, in grand larceny and possession of a stolen motor vehicle. He also has destruction of property and drug paraphernalia arrest, which he was arrested for in October this year. Does look like he had numerous positive tests in that case and then stopped showing up, where he then failed to appear. He does, I believe, have a warrant that was issued in that case. He also was convicted of misdemeanor resisting and misdemeanor hit and run out of this court this year. That case, he also failed to appear at his arraignment and a bench warrant had to be issued. Prior to that, in 2023, he had a felony arrest for possession of a controlled substance with no disposition, a possession of stolen motor vehicle, another possession of controlled substance, an obstructing case that was no issued that same year. He had a felony conviction for attempted possession of a gun by a felon in 2022, a felony conviction for burglary in 2019, and then a gross misdemeanor conspiracy to commit burglary in 2017, as well as some other misdemeanors. So given that history, Your Honor, that this has happened on more than one occasion at more than one location, we do believe bail to be appropriate in this case, especially given his history before this court in failing to appear and failing to comply.
Thank you, defense.
Thank you, Your Honor. As the court is aware, Mr. Valle is already in custody on multiple other cases. So at this point in time, he is not able to afford any additional bail, given the significant amount of bail that is already in place. So we would just ask that the court not set any additional bail in his case.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment, the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case. Bail will be set in the amount of $5,000. That will be bondable with a 10% cash option. If the defendant is able to post that bail amount, I will require that he be supervised by pretrial services, and he must check in with pretrial services within 1 business day. That will be the condition that this court will impose, and we'll go ahead and set a 72-hour hearing, which will be set for January 2nd at 9:30 a.m. Thank you. Next, we have Terrence Gray, followed by Gage Kelly.
Good morning.
Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 9 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. In this case, we're seeking bail in the amount of $10,000 bondable, pretrial supervision. Mr. Gray scores a 9 on the risk assessment as noted. He has a 2023 misdemeanor conviction for drug paraphernalia, a felony grand larceny in 2022, where he was dishonorably discharged from probation in 2024. That was locally. He had a 2021 misdemeanor false statement to law enforcement, a 2019 petty larceny, as well as destruction of property and resisting and destruction of property and false statement convictions. And then in 2014, he had a larceny from person arrest that was dismissed after a completion of a diversion program. So, Your Honor, given that the likelihood of conviction in this case, we do believe some monetary bail is appropriate.
Thank you, defense.
Thank you, Your Honor. In Mr. Gray's case, he is unable to afford any monetary bail. He does have relatives in the area with whom he could reside. His mother resides in Yerington. His brother resides in Reno. He has lived in Northern Nevada for his entire life. He is currently not employed, but was doing side jobs for support and receives government assistance by way of food stamps. He does have regular and consistent contact information that the court could utilize to maintain contact with him as well as his attorney. And looking at Mr. Gray's history and the nature of this offense, the majority of it, as the court heard, was either substance related or theft related type crimes for the support of his substance use. In regards to Mr. Gray's case, he is asking for an opportunity to be released with direct transport to a program should he be apply for one and be accepted with a bed date. Given that history of his, if he is able to treat his substance use disorder and learn the necessary skills to remain sober, he would not be someone who would be a risk for ongoing criminal activity or danger to the community.
Thank you. So I just want to make sure it's clear. Are you requesting an under cognizance release or are you requesting bail with a direct transport?
An under cognizance release with direct transport, Your Honor.
Thank you. So I don't believe that, he would remain in custody. That's why I just want to make sure I'm understanding correctly.
Yes, so he would remain in custody unless and until he was accepted into a program and then would be directly transported to that program. So and or type of situation, monetary bail or.
Thank you. I just want to make sure that I would need a set bail or else he's on a no bail hold. So I just wanted to make sure I was hearing correctly. So the court does find that based on the facts as presented, the Nevada pretrial risk assessment of factors is set forth in NRS 178.4853 and NRS 178.498 that bail is necessary in this case in order to ensure the safety of the community. I will note the likelihood of conviction, the higher risk assessment. Additionally, the concerns regarding supervision is previously outlined. However, he's also been successful with appropriate supervision. So in this case, the court will require that he be supervised by the Department of Pretrial Services and must check in with pretrial services within 1 business day of release. I am setting bail in the amount of $5,000 bondable with a 10% cash option, and this will be a bail or an under cognizance release to a direct transport to an appropriate treatment facility. I do find that that is fair and appropriate given the facts and circumstances. I will require that the defendant be supervised by, as I indicated, pretrial services and be subjected to random drug and alcohol testing. So, sir, you cannot use any controlled substances or alcohol unless you have a valid prescription and be subjected to random drug and alcohol testing. I do find that that is sufficient nexus based on the allegations as well as your criminal history. We will go ahead and set a 72-hour hearing, and that will be set for January 2nd at 9:30 a.m. Thank you.
Thank you.
Gage Kelly.
Thanks. Your Honor, we are requesting to waive Mr. Kelly's appearance.
Thank you. Just to confirm, we can proceed here today.
I'm sorry, Your Honor. Can you hear?
You wish to just waive his appearance for today's proceeding, is that correct?
Correct, just for the first appearances on these allegations. Yes.
Thank you. We're here today for a first appearance bail hearing. Probable cause has been found. The public defender's office has been appointed to 4 of the 5 cases, or 3 of the 4 cases, just for the record. In RPC 2025-065053, the court will appoint the Washoe County Public Defender's Office to represent the defendant as they are representing him in other cases. I do find that that is appropriate. The court is in receipt of the Nevada pretrial risk assessment, which indicates that the defendant scored as an 11 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearings?
Yes, Your Honor. So to begin, Your Honor, as noted, Mr. Kelly does score an 11 on the risk assessment, noting the pending cases out of Second Judicial District Court and 2 points for prior failure to appears. He has had 5 separate failure to appear arrests this year alone. He's also on probation in 2 separate cases where he was on a diversion track for burglary of a motor vehicle. in two separate cases. He also, in one of those cases, pled guilty to petty larceny in two separate counts out of this court. And he had a misdemeanor conviction for shoplifting and drug paraphernalia this year, where he had a failure to appear. So, Your Honor, in my review of these cases, two of the cases will be combined: the grand larceny of a motor vehicle, as well as the possession of a controlled substance, dangerous weapon arrest that occurred on December 24th, yesterday. The two other cases will remain standalone. So, in addressing the two cases that I will be combining first, I'm requesting bail in the amount of $10,000 bondable. DAS supervision or pretrial supervision with testing for drugs and alcohol. He is under supervision, so I think that can be included under the already required testing. And no additional conditions. Regarding the robbery case, Your Honor, I will be requesting bail in the amount of $25,000 bondable. Same conditions: no weapons or firearms, given that this is a crime of violence, and no contact with the Maverick gas station at 480 South Meadows Parkway. Finally, addressing the December 18th possession of a stolen motor vehicle, I'd request an additional $10,000 bondable on that case with supervision. But in total, that would be my request. And I'm happy to restate any of those conditions if you missed them.
Thank you, defense.
Thank you, Your Honor. In regards to Mr. Kelly's case, he is unable to afford any monetary bail. As the state indicated, he was participating in mental health court as a result of his two prior cases, hence the no bail hold that he has currently. So obviously he is not going to be going anywhere unless and until he sees the district court to determine whether or not he will remain in mental health court or be facing other consequences for any violations of his probation. In regards to what I think is appropriate for Mr. Kelly, we would ask that the court consider as an alternative to monetary bail imposed, that the court consider a direct transport to an inpatient program, given that he does have co-occurring issues. He has lived in the area for his entire life. His parents reside in the area. Historically, they have been very supportive of assisting Mr. Kelly in accessing services and being a positive support network for him for his mental health and substance use issues. I don't think the amount of bail for the robbery allegation is appropriate, given that it was simply him pushing past the clerk who was trying to block his exit from the store. I don't think that a weapons, concerns about weapons related to that allegation is appropriate. There were no weapons utilized during that incident, and it was, I believe, one of the witnesses described it as a shoulder check in the probable cause statement. Obviously, there are concerns with substance use, so we have no issue with pretrial supervision and testing or any anything related to ensuring that he is remaining clean and sober. However, given that he is already being supervised by adult parole and probation, I don't know that having him doubly supervised is a good use of the government resources.
Thank you. In the case ending in, for RPC ending in 5-3, which just for the record is RPD 0147550C, that's allegation regarding a robbery, the court does find that the state has met its burden based on the facts as presented, the Nevada pretrial risk assessment and factors as outlined in NRS 178.4853 and NRS 178.498 to find that the state has met its burden by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note the allegations. The fact that the defendant was on in mental health court supervision, as well as the likelihood of conviction. And I'll just note the significant danger to the community is outlined through all these probable cause sheets and the several separate charges that is currently pending before this court, as well as the prior failure to appears and lack of ties to this community. The court does find that bail amount of $15,000 bondable with no 10% cash option is appropriate in this case. The court will impose an order that the defendant must stay 100 feet away from Mavericks in Washoe County, so that will be a no contact order. The court is also requiring that the defendant be supervised by pretrial services, so he must check in with pretrial services within 1 business day of release and be subjected to random drug and alcohol testing. I do find that there's sufficient basis to require that he cannot use any controlled substances or alcohol unless he has a valid prescription based off of the allegations. I'm not imposing the other conditions requested, and we'll go ahead and set a 72-hour hearing, which will be set for, they'll all be on the same date. So that will be just for the record for January 2nd at 9:30 a.m. I am making and incorporating the same findings of facts for all of these matters. And so in the case, RPC case number ending in 56, which is RPD 0144850C, the possession of a stolen motor vehicle, the court does find that makes the same findings of facts and will require the defendant be supervised by pretrial services, where he must check in with pretrial services within 1 business day of release. He cannot possess any any controlled substances or alcohol unless he has a valid prescription, be subjected to random drug and alcohol testing, and bail will be set in the amount of $10,000 that will be bondable with a 10% cash option. The court will do 1 judicial release order for both cases for RPC case ending in 5-4 and 5-5. So for the record, those are RPD 0142747C and RPD 0145046C, the obstructing, resisting, possession of controlled substance, and grand theft of a automobile. The court will set bail amount of $10,000 that will be bondable with a 10% cash option. If the defendant is able to post that bail amount, he will be required to be supervised by pretrial services and be subjected to random drug and alcohol testing. I do find that there's sufficient nexus for all of these cases to require that. I have considered a direct transport to an inpatient treatment facility, but just for the record, the court does not have sufficient information to find that that is the least restrictive means in order to ensure the safety of the community. And given the safety risk in these cases, the court is unable to grant that request at this time. That will be the order of the court, and we will go ahead and set that 72-hour hearing for all those cases for January 2nd at 9:30 a.m. Thank you. Next, we have Nicholas Martino.
Hi, good morning.
Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 2 or low risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. In this case, the state is going to seek bail in the amount of $50,000 bondable, pretrial supervision, testing for drugs and alcohol, no firearms or weapons, and no contact with the named victim, both pursuant to court order and pursuant to statute. We were able to contact the victim in this case. She is supportive in requesting that the no contact order be issued. She did indicate that she has already sought and I believe been granted a TPO. She is still afraid of the defendant. Did express concerns for hers and her children's safety. Did indicate she had been a prior victim of the defendant, and as indicated in the probable cause sheet, Mr. Martino does own or did own a weapon. It indicates to law enforcement that he had sold the firearm. However, in that is a tacit admission to possessing a firearm, despite the fact that he was or is a convicted felon. Despite that low risk score of a 2, Your Honor, we do believe that bail to be the least restrictive means. Mr. Martino's, as demonstrated through the probable cause sheet, is in a extreme state of mind, attempting to commit suicide, threatening to drive to Texas to take the children. He does have some criminal history. It is rather distant. He was arrested for driving under the influence 2018 with no disposition. These are all out of California also, Your Honor. In 2011, he was convicted of felony carjacking. And then in 2009, he had misdemeanor convictions for theft by use of access card and possession of a dangerous weapon. So, Your Honor, despite that low risk score and the fact that the victim may have moved to Texas, given the defendant's statements, threats, and actions, we do believe that he presents an extreme risk to this victim and the children, and bail to be the least restrictive means.
Thank you, defense.
Thank you, Your Honor. So in regards to this case, we would ask that the court release Mr. Martino on his own recognizance with appropriate conditions. In his situation, he was in Reno Behavioral Healthcare Hospital from the time that some of these allegations occurred until he was brought to the Washoe County Jail. He was arrested at Reno Behavioral Health. He was served with that temporary protection order on the 19th of December while he was at RBH. And it is my understanding that there have not been any violations of that protection order, showing that he does have the ability to comply with court orders in regards to following through with that no contact order, given that he was served with that document. The extension hearing on that matter is January 13th. As noted, the alleged victim and the children have relocated to Texas. So in addition to there being the protection order in place, there is also a significant geographical barrier, and the court could impose other conditions to further bolster any no contact orders to ensure that there is not ongoing contact between my client and Ms. Rodriguez or the children. He does also as the court is aware, all of his personal information was verified. He did, again, seek mental health treatment and substance use detox through RBH. So he's now clean and sober and is under the care of physicians and mental health professionals to deal with some of those issues that I think led to some of this escalating allegations contained within the probable cause sheet. So we would ask that that Mr. Martino be released on his own recognizance, given his low NPRA score, as well as the fact that he did seek substance use treatment and mental health treatment after this incident, the geographical barrier and the protection order already in place, that he have no contact. Again, if the court deems it appropriate to bolster that with some sort of electronic monitoring, that could be done as well. But he has lived in the area for a significant period of time. He does have steady employment consistently for the past 2 years with the same employer at the airport, and has been in his apartment for the past 2 years as well. He also has familial support in the area. His mother has relocated from her home in Virginia City to his apartment to assist him as he is going through these struggles with his mental health and substance use and the family separation.
And Your Honor, my apologies. I don't believe I requested it, but the state is going to request house arrest with GPS monitoring.
Thank you. You did not request that. I appreciate then the clarification and defense, just based off of your arguments that you have no objection.
No, Your Honor.
Thank you. Based on the facts as presented in the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note the low Nevada pretrial risk assessment, but given the allegations and the facts and circumstances that discuss the likelihood of conviction, and the court does find that bail is necessary as there are no least restrictive means that can be imposed in order to ensure the safety of the named victim in this case. Bail will be set in the amount of $20,000 that would be bondable with no 10% cash option based off of the nature of the charges. I am imposing a no contact order with the named victim of Rosie Rodriguez. And Kate, can you confirm that the spelling that this court has is Rosie last name Rodriquez. And you are on mute
It's Josie, Your Honor, with a J, not
with a
Rose.
J.
Yes,
Thank
Your
you.
Honor, and it's Guez, Your Honor.
Thank you. The court does find, sir, that you are to have no contact with the named victim in this case, and that begins immediately. You cannot contact or attempt to contact her in any way and must stay 100 feet away from her at all times. Cannot contact in any way, including in phone, person, text, email, electronic means, or through social media, either directly or through an agent. That means someone working on your behalf. I am imposing the condition that this is also not only just subject to this judicial release order, but pursuant to NRS 178.4845 for a period of 120 days. If you violate this court order, you could be charged with a misdemeanor found in contempt pursuant to NRS 22.010, have these conditions modified, have your release revoked, be remanded to custody, and or any other legal punishment. I am requiring that you be supervised by the Department of by pretrial services, and you must check in with pretrial services within 1 business day. Given the facts and circumstances here today, I am also imposing the condition that you be subjected to GPS monitoring, which must be installed within 24 hours of release. I do find that that is necessary in order to ensure the safety of the named victim, but that alone is not a least restrictive means. That is the state. Did you have something else that you wish to add?
Yes, Your Honor, just regarding testing, I was unsure if you wanted to include that as well.
Given the facts and circumstances, the court does find that it is appropriate to require random drug and alcohol testing. So the court will require that the defendant cannot use any controlled substances unless he has a valid prescription to be subjected to random drug and alcohol testing. That will be the order of the court, and we'll go ahead and set a 72-hour hearing, which we set for January 2nd at 9 a.m. Thank you.
And Your Honor, my apologies. One more thing was the no firearms or weapons clause given the crime of violence.
Given the allegations that a firearm had previously been at issue in his criminal history, the court will impose the condition that he cannot possess any firearms or weapons. Thank you.
Thank you, Your Honor.
Well, if you can post, it's 20,000.
Thank you. I'll just turn to the Washoe County Jail just to confirm it's the court's understanding that there are no additional individuals in the courtroom. Just wanted to confirm before we log off for the day.
That is correct.
You don't have the ability to call her.
Thank you, everyone. Have a wonderful rest of your day.